Screen is visible. Hello.
Yes, ma'am, it's visible.
Screen moving also. Hello.
Yes, ma'am.
Hello.
No problem. Yes, ma'am, it's moving.
Fine. Thank you.
Yeah.
Thank you for. So now the today's topic, that is National Intellectual Property Awareness Program. First of all, I would like to introduce the IP system which comes under the Controller General of Patents and Design and Trademark, that is known as CGPTDM. The main head office, that CG office, is located at the main office of CGPTDM. We have Rajiv Gandhi Institute of Intellectual Property and Management, which is located at jurisdiction. We have 4 patent offices: Kolkata, Delhi, Chennai, and Mumbai. Kolkata is the head office, and Mumbai is the CG office. We have 1 design office that is located at Kolkata. We have 5 trademark offices. First is Mumbai, Delhi, Kolkata, Chennai, and Ahmedabad also. Geographical Indication Registry office is located at Chennai. And Semiconductor Integrate Layout Design Related Office located at Delhi office. And Copyright Registry also located at Delhi office. So this is a system which comes under the Ministry of Commerce and Industry. This is our official website, www.ipindia.nic.in, where you can get all the public information of all the intellectual property rights, patent, designs, trademark, GIE, and public courses, controller decision, tender, notice, recruitment, any public information you can get from our website. What is intellectual property? Why there is a need to protect intellectual property? See, first, what is property? Let forget the word intellectual. What is property? See, when we buy our house, when we buy our flat, any property, any immovable property, when we buy, the first thing what we do the registry of that lot, right? That this is my property. I am the owner of this property. This is my flat or this is my land, right? Like that, this is the intellectual property. That is the intangible form of property. This is created by human mind. The creation of human mind and expression of human mind that have commercial value. How commercial value? There is an economical significance of the each and every intellectual property. Why there is a need to protect your IP rights? If you have a specific idea, then you can use your brain, you can apply your mind, and you can use your resources, you can use your labor, and you can create your intellectual property. Intellectual property in the form of any form, product form, process form, logo form, your publication form, your drama, your activity, any creation of your mind can be considered your intellectual property if you protect that. How you can protect that and why there is a need to protect IPR rights? Because today is the time of technology, right? Technologies are rapidly changing nowadays. Investments in research, development, production, everything becomes very high. Marketing also became very high. Product life becoming very shorter and shorter. Industry has become very competitive environment. Today's, I think, the need of time only. So now intellectual property, if you, I give you the example of that one in 2005 or 2006 to 2008, we were using that Nokia small phone and the Tata Indicom black phone, right? And now we are at iPhone. So how technology rapidly changing, right? So there is a need to protect your rights. So what are those rights? I will discuss in detail later on slides. So there are three important criteria, or there is a three important properties of the all intellectual property. First, all these rights are the exclusive right. Exclusive right means these are the monopoly right for a limited period of time. What is that limited period of time? I will tell you in the later on slides. This is exclusive right. That means you can exclude others to use your product, for making your product, for manufacturing, for selling, for every right you can exclude other. You are the owner of that property, right? That is your monopoly right. This is the first benefit. The second property, you can say the second characteristics of the intellectual property is territorial right. Territorial means if you are applying intellectual property right in the Indian government office or in the Indian patent office or Indian trademark office or Indian GI office, you are going to get that protection in India territory only. That right will be applicable in the India. If you want to protect your right in any foreign country, like if you want to protect your, if you think that my product is there is a market in US or in Japan, and so you need to file that patent application in the Japanese patent office or European patent office or US patent office. So that will be applicable in their countries only. So if you are applying a right in India, then it will be applicable in Indian territory. And the third important part is all these rights are be assignable or licensable. Like we authorized our property, we give some power of attorney to anyone that you can use my property, right? We assign our right. Similarly, you can assign your intellectual property rights to anyone. Suppose you have a good quality product, but you don't have money to execute your manufacturing, you can say production of your product, and you are not able, but you have quality product which is granted patent. Right? So how you can make the economical benefit from that product, that intellectual property? You can assign your right, or you can license it to someone who can execute your plan, and he will pay the royalty to you. You can make benefit. Any industry, if you have a good product, you have good invention, the company will approach you. Give me your product, I will pay you money. Right? So you can assign your right to anyone. So these are the all these intellectual properties are the exclusive rights, territorial right, and assignable rights. Now come to the, so how many properties are there? Patents, designs, trademark, GI, that means geographical indication, copyrights, and along with these 5 rights, there is a semiconductor integrate circuit layout design as well as the trade secrets. So what is patent? Patent we will discuss in detail in today's session. As per the Indian patent law, the slide is visible now. As per the
Yes,
Indian
ma'am. It's
patent
visible.
law,
Visible.
only product and process, sorry, only product or process can be protected under the patent law. Any product or any process. Designs. What is design? Design is the, you can say, what is visible to you. That is design. That I'm not talking about the mechanism, and see, because patent is related to the technology. But design, which is visible to you, that means the shape, configuration, pattern, ornamentation, right? Applied to an article by industrial process. If I give, I think that should be appeal to the eye. If I give you the example of Bisleri bottle, right? Whenever we see Bisleri bottle, we all know that this is the Bisleri can, because no other company can use that design. Why? Because that design is protected by the design patent law. So no, it doesn't matter whether distillery is written over there or not. You will get to know that this is a distillery bottle. Similarly, trademark. Trademark, we all know that sound mark, trade names, slogan, we can protect under the trademark. I will show you the examples also. GI, GI is the, if I give the example of GI, Agre ka petha in Maharashtra, Alfonso or Hapus mangoes, Bikaneri bhujia, Goa feni, like all these are the examples of the GI. And what is copyright? Copyright means that any artistic work, publication, cinematographic work, drama, musical lyrics, drawing, anything can be protected under the copyright. And along with this, there is a confidential agreement between the government and the applicant. I think Coca-Cola formula. We all know that nobody knows the formula of Coca-Cola, right? Because that formula is protected under trade secret. KFC chicken sauce. That is the one another example of that trade secret. And semiconductor integrated circuit layout, which consists of semiconductor material with a transistor element. I think rare of applications come for the semiconductor integrated circuit layout. So if I give you this example of this laptop, so LED display, I think this product, the whole product can be, the technology can be protected under the patent law. The shape of this laptop can be protected under the design law. This mark of Apple can be protected under the trademark of this company. User manual of this laptop can be the part of copyright. And the layout of the integrated circuit is the part of semiconductor integrated circuit design layout. So in one product, company can protect 5 intellectual property rights. So this is the beauty of IP. So validity of all the IP rights. Patent will be applicable 20 years from the date of filing or date of priority. That means on which date you are going to disclose your invention to the government or to the patent office. The right will start from that date up to 20 years. For that you need to file, you need to pay renewal fee every year to get alive your patent. There is nothing called global patent or international patent. As I already discussed that the patent rights are territorial rights. Right? So there is nothing called global or international patent. There is a route to file an international patent in the different foreign jurisdiction, but international patent जैसा कुछ नहीं होता. Design. What is design? Design is initially for 10 years. Design will be applicable for 10 years. After that, you can renew up to 5 years. Trademark also for 10 years. After that, you can renew for the infinite time. GI is initially for 10 years. After that, you can renew infinite time. Copyright for drama and like artistic work, musical work. So the right will be for the author for his lifetime and plus 6 after the 60th year of his death. The right will become for the author. And broadcasting right, cinematographic right, I will show you in the later on slide. I think for that 25 years the term will be. And any person or any legal representative of person, firm, partnership, small entity, any individual, any corporate body can file for the intellectual property rights except GI, because GI is not the right of individual. A group of can enjoy the right of GI. Suppose a small village of Maharashtra has registered GI for the Hapus mangoes, right? So the group of that people, the people of that village can enjoy that benefit because they belong to that area. Right? So GI can be filed by the group of people. This is the not right of individual. If I talk about the Bikaneri bhujia, so in Bikaner area, all manufacturing plant can use that their GI sign, which is registered. So now comes to the patent. What is patent? one by one we will discuss with example. Patent is the exclusive right granted by the government to the patentee for a limited period of time. What is that limited? 20 years. To exclude others from the act of making, using, offering for sale or selling or importing the consideration of the complete disclosure of your invention. You need to disclose each and every technical aspect of your invention to the government. Then you will get the patent. This is the first example of the long back ago, 1856, George Alfred Dippening. He was the civil engineer of the Calcutta. He filed a petition to the government that give me the exclusive right or privilege right to me for my invention, that is efficient Pankha pulling machine. This was the first invention which was asked for the user the exclusive rights. These are the inventions of India, which is already granted. This is a nano car providing the opportunity for
I guess there is an internet issue.
Ma'am, we can't hear you.
hello.
Yes, ma'am.
Why it got disconnected?
Yes, ma'am, we hear you now.
Okay, we were on this slide now only.
Ma'am, we
Can you
can't
see?
see.
We can't see slides, sir.
Now?
It's not visible.
It's not visible. Now?
Yeah, we can see now. Subject matter of copyright is okay.
We were on this slide now, or maybe it was disconnected. I don't know. Hello. Trademark I have already discussed, right?
Yes.
The subject matter of the copyrights, like literature work, artistic work, dramatic work, musical work, sound recording, cinematographic work can be protected under the copyright. If I give you the example of that Antakshari program, which is it belongs to the GTV. See, producer has all the right of that program, but broadcasting rights are reserved for the GTV only. Only GTV can play that Antakshari program, and without GTV permission, no other channel can execute that program. So this is the part of copyright protection. This is a symbol used for the C is used for the copyright protection, and this is for the broadcasting right performance. So cinematographic film and sound recording 60 years from the date of publication. That will be the validity of copyright. Broadcasting right will be 25 years, and performance right 50 years. And for the publication, I have already discussed that lifetime plus after the 60-year of a state. Now come to the industrial design. I already discussed that shape, configuration, pattern, or ornamentation, which is visible to your eye. That can be protected under the Design Act. That the term of the design will be 10 years, and after that 5 years you can extend. So these are the few examples of the design article, like any furniture, any watch, mobile models, motorbike models, any product can be protected under the design law. Set also you can protect. Same set means the number of articles of the same general character ordinarily sewn together or intended to be used together, all bearing the same designs, like jewelry designs, crockery designs, furniture designs. You can protect under the design. Design we have only Kolkata office. If you want to file physical, you can file any of the patent office, and after that it will be digitized and it will be examined only at the Kolkata jurisdictions. And fee, everything is online nowadays. You can pay online. See, these are the few examples of the GI. Rasgulla, Darjeeling tea, Nagpur oranges, Nasik grapes. So all these things can be protected under the GI. What can be protected? Agricultural product. The indication of goods that have a specific geographical origin and possess quality of the reputation that are due to their origin. Agricultural product, manufactured product, handicraft product, or food stuff. Like Bikaneri Bhujia, Radlam, Save, Malabar pepper, Agarbatti, all these are the examples of these products. Any product which have specific origin, specific reputation due to the quality of that particular product, due to the origin of that product, can be protected under the GI. Now come to the patent in details. What is invention? Under section 210 of the Indian Patent Act defines the definition of invention. What is invention? Invention means a new product or process involving an inventive step and capable of being industrial application. Novel, it should be novel. new or novel means it should not be disclosed anywhere in the world, in India, world, anywhere, in the form of any document, any newspaper article, any publication, should not be disclosed. In terms of YouTube video, Facebook article, no disclosure should be there before your disclosure. It should be novel. It should be new. Then only novelty can be acknowledged with the invention. The second important criteria is the inventive step. What is inventive step? Inventive step means a feature of an invention that involves technical advancement as compared to the existing knowledge or having economic significance or both, that makes the invention not obvious to a person skilled in the art. That means the thing which you are going to claim, which is novel, it should be inventive in terms of the economical significance or technical advancement. It should be technically advanced, which is already available in the market. If you are going to claim a device, or going to claim a machine, or you are going to claim a medicine, or any product, or any process, that should be technically advanced, and you need to prove, and you need to provide the documentary proof or experimental part of that particular invention, that my invention is technically advanced over the known product. Or it should not be obvious to a person skilled in the art. Who is person skilled in the art? Suppose our mom and grandmoms are working in the kitchen, right? And they are person skilled in the art in the cooking. And we are working in the pharmaceutical industry, suppose. So we are the person skilled in the art in the pharma field. Suppose if you all of you are working in the field of engineering, in your field like mechanical engineering or computer science, whatever is your field, if you are working in that particular field, and you could easily understand this is an obvious invention, I can do this by reading some prior art, and if it is obvious, then you cannot claim. It should not be obvious to a person skilled in the art. There should be some unexpected technical advancement needs to be there in your invention, so that your invention can be acknowledged inventive invention. And the third important thing is it should be industrial applicable. It should be used in or made in industry for the industrial purpose. There are few exceptional cases under Section 3 of our Indian Patent Act. Maybe you are claiming few inventions, but those inventions are not patentable under Section 3 of the Indian Patent Act. What are those inventions? The invention which is frivolous or which is contrary to the well-established natural law. If you are claiming frivolous things, suppose if you are claiming a machine or any engine which is giving 100% output without giving any input, so that will be against the natural law, right? Input is required to get output. Without petrol, we cannot drive any vehicle, right? So input is required. Like such types of invention cannot be patented. If you are claiming such thing which is contrary to the public order or morality, that is against the morality, or that is prejudicial to the human health, animal or plant life, or the environment, that will also not patentable under Section 3B of our Indian Patent Act. If you are claiming any mere discovery of scientific principle, or any discovery of a living or non-living things which is already occurring in nature, that cannot be patentable, because discovery of anything cannot be patented. Invention needs to be patented. What is Section 3D? I just want to ask that any one of you are related to the chemistry, or all of you are engineers? The field of all the students are engineer, right? Engineering.
Most of them are from mechanical and civil, ma'am.
Okay. Yes. So this Section 3D is actually most relevant section for the pharma people, but I will discuss in short that new form of any known substance, new property of a known substance, new use of a known substance, new use of a known process, or mere use of a known machine or apparatus. All these things are not patentable. Suppose if you are claiming a medicine which is already known for the cough, cold, and fever treatment, and now you are telling that my medicine is the useful. This medicine is used for the cancer treatment, right? So that will not be patentable, because that drug is already known in the market. and you have only discovered that new property or new use. Like that same thing applies to the machine or apparatus. If you are claiming a new use of a machine or apparatus or device, that cannot be patentable. Suppose if you have uh, electrode, or electrode is already granted specific characteristics of the specific specific electrode with the uh, anode or cathode, whatever you have already claimed is known. Now you are telling that I am using this electrode in the water purifier system. Now I am using this electrode in a particular cell or battery. So that use cannot be patentable because invention lies in the electrode only. It doesn't matter where you are using that electrode, right? Section 3E also, if you are mixing two or more things, without any synergistic effect, you cannot make the combination or mere admixture. You need to prove some unexpected synergistic effect. This is applicable for the pharma people. Therefore, I am not discussing more about the section 3D and section 3E. If you have simply mixed salt and sand, so there is nothing. If you are mixing A plus B, then there is a need to produce C with the unexpected synergistic effect. Then only you can get the patent for that particular mixture. The 3F is applicable for the engineering people, that the mere arrangement of the rearrangement or duplication of known device, each functioning independently of one another in a known way. Right? If you are claiming mere arrangement of two devices, that cannot be patentable. Like if you have attached umbrella with the fan, bucket with the torch, so there is nothing in this invention. If I give you the example of the geyser technology, earlier, long back ago, we were using that rod, right, for warming the water, for the heating of water. We were using that rod, and we put that in bucket and we touch the water. That पानी गर्म हो गया या नहीं हुआ. फिर हम switch on करेंगे, फिर touch करेंगे, then switch off करेंगे. It was complicated to get hot water, but now the company created geyser. What is geyser? The geyser is also a plastic body attached with that particular rod. But why this is a patented technology? Because this comes with the automatic feature, technical advancement feature. That is not the duplication of known device or rearrangement of bucket and rod, right? There is some unexpected automatic feature, and that geyser technology makes our life easier. Right? So there is a benefit. So only you can get the patent for that particular device. There should be some application part which should be technically advanced. If you are claiming agriculture method or horticulture method, which farmers are usually using in their farm, like plant growth regulator or spraying method, you cannot claim that because that is applicable for all the farmers in our country, or every farmer can use this method. So this is not the part of patentable subject matter. This is not the part of monopoly rights. If you are claiming medical or surgical method of treatment, method of administration of any medicine, diagnostic method, that cannot be patentable. Suppose if you have a particular kit for the anti-diabetic, then you can claim that product, you can claim that medicine, you can claim that kit, but you cannot claim the process for using that kit for the treatment of diabetic patient. Right? So any process which relates to the diagnosis of any treatment of animal or human being to render them free of disease cannot be patented under Section 3 of the Indian Patent Act. If you are claiming any plants or animal part or their whole, that also cannot be patentable. This relates to the biotech people, so I am not going to discuss this part. If you are claiming a mathematical or business method or computer program per se or any algorithm, that is also not patentable subject matter. Product per se, that means computer program per se is not patentable. But if you are coming with the computer program along with hardware, that means you are coming with a device with program, right? Then only you can get the patent or method of using that method in that particular device. you can get the patent for that. But only program you cannot get the patent. 3K section defines the computers related patent technology. Literature work, dramatic work, musical work, artistic work, all television, broadcasting, all these rights belongs to the comes under the copyright. This is not the patentable subject matter. A mere scheme or rule or method of performing the mental act or method of playing any game is not the part of patent protection. If, presentation of information, topography of integrated circuits also not patentable subject matter. A very important thing is section 3B, which is our traditional knowledge cannot be patentable. So we all know that turmeric powder has wound healing property. We all, since long back, traditionally we are using for the wound healing property turmeric powder, and like jamun seed we are using for the anti-diabetic property. So such type of knowledge is traditionally known. The turmeric patent was granted once in the US patent office by the patent office in the US Supreme Court, and the CSIR India opposed that patent, that this is the traditional knowledge of India, and that patent was revoked in US. So such type of inventions which relates to our traditional knowledge which we are using, that is not the part of patentable subject matter. And the very important things, the invention which relates to the atomic energy, which comes or which falls under the atomic energy section 1 of subsection 1 of the section 20 of the Atomic Energy Act 1962, which contain the explosive material or radioactive substance like uranium, beryllium, graphite, enriched lithium, thorium, plutonium. If you have invention, in which invention you are using such substance, that cannot be patentable because this relates to defense purpose or the security purpose. Who can apply a patent? Any true and first inventor of the invention can file patent. It's an assignee of that true and first inventor. Any company, any startup, any small entity can file patent application. Legal representative of any deceased person can file patent application. Application may be made alone or jointly with any person. Any individual person also can file. Jointly can also can file. So earlier it used to take 4 to 5 years to get a patent application, patent granted patent. But nowadays Government of India has introduced the expedited examination procedure to get like early. You can get by going through the expedited route. You can get the patent within 8 months or within 1 year. Who are eligible to file expedited requests? There is a procedure to file expedited request for examination. You need to pay extra fee for that to get early patent. So what is that criteria? If you are working as a startup or you are working as a small entity, if your firm or your company is working as a startup, then you need to provide a certificate from the Department of Ministry and Government that we are eligible startup and we are eligible to file expedited request. Then you need to file Form 28, which is available at our website. That we are startup, then you are eligible to file expedited request for examination. And if any applicant is a female, then also you are eligible to get to file expedited request. Any government department, government affiliated college, your institute, all are eligible to file expedited request. If you are coming through a PCT route, PCT is the Patent Corporation Treaty, which is an international route. If you are selecting India as an international search authority for your application, because PCT is a different topic, I am not going to discuss here. This is a eligibility criteria. If you are selecting India as an international search authority through PCT route, then also you are eligible to file expedited request for examination. And along with these, if any foreign country has signed the agreement with the Indian government or Indian Patent Office, recently Japanese Patent Office has signed the assignment with the Indian government. Now the PPH agreement is there. The Japanese Patent Office is also eligible to file expedited request in the Indian Patent Office. For more detail, if you want to read about the expedited request, our section Rule 24C, So please read our rule patents rule 2003, which is available at our website. The category of the applicants can be natural person, startup, small entity, and other industry for the purpose of fee only. So what is the initial fee? If you are individual or small entity or educational institute or individual person, then only 1600 rupees you need to pay at the time of filing. If you are an industry, big industry, then 8000 fee is applicable for that. That is application form, that is known as form 1. All the formal information, that is your address for service, your email address, your title, who is applicant, who is inventor. Inventor needs to sign that I am assigning my rights to the applicant. That is proof of right. Every formal information needs to be provided in form 1. Form 2 is the technical form, which disclose your invention. Title, abstract, complete specifications, claim, drawings, model, everything which relates to the technical information of your invention needs to be provided in Form 2. Up to 30 pages or 10 claim, there is a no fee for Form 2. After that, per page or per claim, you need to pay extra fee. Form 3 is related to the foreign filing details. If you have applied in any foreign country, then you need to provide that information to the Indian government or to the Indian Patent Office by filing Form 3. That is statement and undertaking. There is no fee for that. Form 5 is the declaration of inventorship. Suppose if your college is going to file an application for a patent and you are the inventor of that application, that means you are working on that project and your college is going to file patent application for that. That means your college will declare that these are the true and first inventor of our project. That is declaration of inventorship type. Form 18. Form 18 is the request for examination, and one more form is there, Form 18A, that is expedited request. So initially 4,000 you need to pay 20,000. Expedited request you need to pay extra fee. You can refer our patent rule. So this is the initial fee to filing a patent for the individual person and the industry. And for more detail, you can see the first schedule of the first fee schedule, which is available at our patent rule, which is available on our website. So this is the jurisdiction of the filing of the patent application. So earlier it was physical filing. Nowadays everything is online. You can file the patent application online. There is a digital portal of our website. But you need to select your area, the field of your invention, where invention belongs. Right? If you are living in the Maharashtra, Gujarat, MP, Goa, then you need to select your jurisdiction Mumbai. If you are living in the southern part of India, then you need to select jurisdiction Chennai. If you are living in the North India, like Haryana, Punjab, Rajasthan, UP, then you need to select jurisdiction Delhi. And rest part of the India can select India. Hello. So these are the mandatory form, which I already discussed, that Form 1, Form 2, Form 3, Form 18, Form 28, Form 5, Declaration of Inventorship. Each and every application published under Section 11A after the 18 months of the filing. But if you want to your patent application get early published, then you need to file request for early publication by filing Form 9. So your application will be published within 1 month of the date of filing of that particular Form 9. Form 26, the general power of attorney. If you are directly filing, then there is no need to file Form 26. If you are coming or if you are filing with, through a patent agent or patent attorneys, then you need to assign your right by filing the power of attorney within 3 months of the date of filing of your patent applications. So these are the mandatory and optional form which is required at the time of filing of the patent applications. If you want to see the format of all the forms, how to fill and every format, all these forms, because due to the shortage of time, I have not included all the formats of all forms in this presentation. If you want to see, I can communicate through email or when or all the forms formats are available at our website also. You can go through that. So the most important thing is the form 2, that is the complete specification of your invention. There should be a specific, there is a specific format